You know what the #1 killer in this country is? You'd never guess. It's food. Food is supposed to sustain us. A wise man once said, let food be thy medicine. However, the way it's being marketed to us, the portions in which we're consuming, it's turned into a poison. It doesn't have to be like that. What you need is an ally. This is something that should be approached 24/7. We have the solution. The morning time, the midday, the nighttime. We got you covered.
I'm attorney Ken Nugent. If you've been injured, here's what one call, that's all means for you. It means you have 40 lawyers and 200 support staff working for you. It means proactive communication so that you never have to wonder
long it took you to find the skip button? That's how long it takes to send cash direct to bank accounts around the world using Western Union.
If I had co-counsel earlier in my career, I think without a doubt, I would have been able to free more innocent people from prison. I was really
Hey Georgia, looking for quality, affordable health insurance? At georgiaaccess.gov, there are many great ways to find a plan that meets your needs and budget. Open enrollment begins November 1st. Georgia Access. Your health, your way.
Judge, everybody further counsel.
Thank you, sir. Okay, as I mentioned earlier, the court has had an opportunity to take a look at the motion to declare OCGA code sections 1611, 131, and 133 unconstitutional under bar and or strike prior convictions in Acts 77, 175, and 191, and current charges, counts 53 and 65. And the court's had an opportunity to also take a look at supplemental authority submitted by Mr. Harvey and similarly situated defendants under this indictment, 22 SC 183572, in Range versus Attorney General of the United States, as well as the second notice of supplemental authority in motion to appoint expert historians and other relief, as well as the third notice of supplemental authority in motion for court to appoint expert historians and other relief, and the fourth notice of supplemental authority to appoint expert historians and or other relief, as well as the state's motion or state's response in opposition to Cormarius Nichols' motion to declare OCGA 16-13-131 and 16-11-133 unconstitutional. The court further is aware and has taken into account Kuhlman versus the state, and that can be found at 892 Southeast 2nd, 753, 2023, as well as Massey versus the state, which is currently on appeal to our highest court and is located at S24A0131 in particular. The court will distinguish a couple of different things in terms of the matter at hand and of the cases that have been cited for the court's consideration. Kuhlman involves a convicted felon who filed suit against the state for declaratory judgment that the State Board of Public Safety's denial of an application for relief from statutory prohibition against the felon in possession of a firearm under the exception to the statutory prohibition for convictions for offenses pertaining to antitrust violations, unfair trade practices, or restraint of trade, violated state law, and state and federal constitutional rights to bear arms. The Superior Court granted the state's motion for summary judgment on all claims. The felon's application for discretionary review was granted.
In Coleman, the Justice Ellington writing for the court, divisions 1, 2, and 3, this can be distinguished because the Superior Court erred on ruling on the issue of sovereign immunity, and the applicable section that Coleman was relying upon is 1611-131 Delta, which is not the applicable statute that is involved, or subsection involved in this particular matter. However, and in Division 4 and Division 5, the court gives quite some analysis on when interpreting a Georgia statute and a federal court decision construing a federal statute rule have persuasive value only to the extent that the language and content of the Georgia statute at issue are materially similar to the federal statute or rule, and they cite C. General Motors LLC versus Buchanan, 313 Georgia 811 pinpoint 821 2 Charlie, where the language of a Georgia statute deviates from the federal rules of evidence or the persuasive value of the authority interpreting and applying the federal rule is diminished. And then they cite Stubbs versus Hull at 308 Georgia 354 pinpoint 358. In construing a Georgia statute that closely tracks federal statutory law, we may look to federal court decisions and commentary interpreting federal statutes or persuasive authority. I'm skipping a little bit, but it says the federal statute that contains language similar to OCGA 1611-131D, which is part of the Gun Control Act of 1968, originally enacted, excluded from the following the felonies that disqualify convicted persons from acquiring or possessing firearms. Federal or state offenses pertain to antitrust violations, unfair trade practices, restraints of trade, or other similar offenses relating to the regulation of business practices as the Secretary of the Treasury may regulate or designate. So I believe that that is different than the matter that we have at hand. I'm also going to turn and talk a little bit about Massey, which is currently on appeal to our Supreme Court to be argued in January of 2024 as designated and told to the court by Mr. Harvey and I think earlier Mr. Steele. In Massey, as argued by Mr. Harvey and others, are a couple things. What is the appropriate analytical framework for deciding Second Amendment claims? Does the crime of possession of a firearm by a first offender in Georgia have historical antecedent? Does the Second Amendment render appellant, in this case Massey's, prosecution for the crime of possession of a firearm by a first offender unconstitutional? So we have a distinguishing issue in our case is that we don't have this particular applicability of this particular first offender statute, and that we have the other portion as defined in 1611-131A. I'm sorry, let me make sure I got the right statute. I'm sorry, A and as B, and B. It's a disjunctive statute, so it has several ways that that statute can be interpreted, and in this particular section, or who has been convicted of a felony by a court of this state or any other state. So that is a distinguishing factor in this particular matter that we have in hand. The issue that was raised by Mr. Harvey is, did the state build a record in the trial court as to why this law doesn't run afoul of the Second Amendment? And but distinguished Massey, unlike the circumstance we have in the case at bar, is that Massey's Second Amendment rights prohibit his prosecution for illegally possessing a firearm, particularly because he's not a convicted felon. So in this particular circumstance, that is different than in our case, because then it just, as distinguished in the argument made by both counsel this morning, whether or not that is, you are then a law-abiding or responsible citizen as a Second Amendment application. And similarly, Mr. Harvey argues that the state has failed to provide proof and to meet his burden in persuasion. I believe the state's brief subsequently covers that particular historical and as well as the record in the trial court as to why this law doesn't run afoul of the Second Amendment. I'm also going to take, for the purposes of this particular argument, Defendants 1 and Defendants 2. Mr. Uhelski, do you have anything else do you want to supplement, or do you wish to adopt Mr. Harvey's D1? As terms of development, of historical development.
I have nothing to offer, no opinion to share on that, Your Honor.
All right. Because I'm offering you, do you have anything else to show that the historical development of the United States Second Amendment? It appears that Massey would require the state to do some particular historical development of the Second Amendment. I believe your brief does adequately address that. However, that's not evidence. That's just a pleading in this case. Mr. Harvey submitted evidence for this particular point. So if you want to adopt it, that's fine. I don't have any issue with it, but I'll accept it as evidence in this case as to the development of the Second Amendment, along with your brief.
I beg the court's indulgence for just a moment, Your Honor, if that's all right.
While you're thinking about that, I'm also looking at Massey, and it appears that Mr. Harvey's reliance or discussion about range and Bruin, the Bruin analysis would require some historical analysis, and it appears that the Eighth Circuit has relied upon the Supreme Court's assurances that gun restriction laws are still viable, and it conducted a fairly extensive required historical Bruin analysis, and that's
Your Honor, if I may, I'm going to ask the court, to the extent that Your Honor is asking us, do we adopt Mr. Harvey's exhibits as sort of the exclusive way of looking at the historical analysis that is, or would be required if you get past that first prong of Bruin?
Yes, that's one way to look at it.
So the answer to that is we don't say there's anything wrong with him putting that forward. If Your Honor is saying to us that the state is required to, rather than apply, supply the historical analysis in the pleadings, Your Honor would prefer that we kind of physically put into evidence exhibits of sort of the historical analysis that we have put in our response. I would just want a clarification on that issue, because I don't want to rest here and then not have the historical evidence that the court would like to look at if it's not in the right format. Let's say, is the court requiring that we put into evidence these sort of statutes and these items of historical scholarship that we've referenced?
And looking at Massey, it would appear that that would be required to show there's an historical, because you have the burden of proof to prove that. It says the government, because.
Well, is it the burden of proof or persuasion? I mean, this is going to be from Bruin, and this is the United States Supreme Court. The question is whether historical precedent from before, during, and even after the founding evinces a comparable tradition of regulation, and it assigns the burden of showing the historical analog supporting the regulation. I'm not aware, and I do not understand that to mean that this is an evidentiary hearing wherein we would need to put in like sort of the physical, I guess, copies of the statutes and things like that. If the court is of the opinion that that's required, we're happy to provide that and supplement what was presented today with all those things. But I do understand the court.
That's my concern looking at Massey and looking at what the argument in Massey is at this point in time, is that, and that's why Mr. Harvey presented this particular evidence, because it would seem to me that that's what the Supreme Court's probably going to take up in our Supreme Court, as well as the others may take up to determine whether or not there is a constitutional framework in that respect. So that's why I'm saying that it might be helpful to include that in the record.
Would Your Honor permit us an opportunity to supplement the record as described here? And if the court's, I'm sure the court has looked over the pleadings. I'm not going to belabor that. But if the court believes that it is required that we sort of submit these items of historical scholarship and historical and legal, we would ask for an opportunity to supplement the record. I can say that for my part, it was not my understanding that sort of evidence in the form of actual statutes and these law review articles and these decisions that are provided in the pleadings would be necessary to decide the issue today, Your Honor. Would the court be amenable to that at this time?
Yes, but I don't have a lot of time because you're starting on on Monday, and if you're not, and I need to rule on it so you can present proper argument and presentation of evidence.
How much time would Your Honor be willing to give us to summon all this and provide it? I can tell you we'll do it at the court's pleasure. We'll do it in a hurry, Your Honor.
Yeah, and finishing the citation for Jackson, that's 69 F 4th 495 8th Circuit 2023. And in the 8th Circuit, they concluded that in determining the sufficiency of historical evidence to support the 922G1, we conclude the legislature's traditional employment status-based restriction to disqualify categories of persons from possessing firearms. Whether those actions are best characterized as restrictions on persons who deviated from the legal norms or persons who presented an unacceptable risk of dangerousness, Congress enacted with an historical tradition when enacted 922G1 and the prohibition of possession of firearm by felons. So, it seems to be Mr. Uhelski and Mr. Mr. Harvey, that looking at tandem of Massey and Kuhlman, that in order for this case to be properly reviewed on appeal, that you would probably need to have some evidence to support in the record to support the historical analysis. It's listed in your brief, but as Mr. Harvey was quick to point out, he's the only person that's put any evidence in at this point in time in the historical development. So, and I believe that that can also include the statutory and case law development of this particular statute. So you may come up with the same conclusions he's come up with, and with the legislative history as to why we have 16, 11, 131, and 133. I believe your discussion adequately handles it, but there needs to be something that would be admissible or be put into the record. So I'll leave the record open until tomorrow. At noon for you all to submit something, and then I'll make a final ruling on that issue at that point.
And Judge, I understand what you have just requested in the additional time, but let me object to that. This has been on, this is the third time this case has been on for argument. I've made the same arguments over and over again. The state has simply failed to meet their burden. I think the case law is clear. I object to giving them a second bite at the apple. I think we are in a position for you to rule and or to sever those counts out and or give us a right for interlocutory appeal on those particular counts as well. So I'm going to object to additional time to allow the state to do what they should have done when we were here for hearings the last two times. So just want that on the record.
All right, so noted, sir. I'll take that over your objection, sir.
Okay, thank you, Your Honor. Right. Understood.
And I'm assuming I get time to respond?
Yes, Mr. Harvey. You certainly may. I would come with your arguments because I am going to rule at the conclusion of tomorrow. I mean, I'm basically ready to rule, I think, at this point in time, but I'll give the state, given the position of the cases that the court has read this morning, and because I want to get this right on appeal and preserve it for appeal correctly, the opportunity to do so. So if you have anything else, you can bring it on Friday, bring it on tomorrow, and we can hear it, okay?
Well, I don't know what else I'm going to have because I don't know what the state is going to come up with, number one. I'm ready for the court to rule now because this was our opportunity and this is our record.
I understand that, sir.
All right.
Okay. All right, thank you. All right. Okay, councils, I want to take up one other matter and then we're going to go to lunch, okay?
Okay,
Hold on, everybody. I'm trying to get the feedback for y'all. Hold on.
as a non-record aside, Judge, it is Mr. Box's birthday today, and it should be noted that he is wearing a pair of Sansa-belt slacks and tennis shoes.
And here it is, it's proof of the record. He said to do.
Happy birthday, Mr. Box.
Thank you.
And many more, sir. But if you're going to wear tennis shoes, you need to upgrade your tennis shoe game.
These are the style.
I'd recommend you not say anything for.
My client wouldn't let me wear his shoes, so I had to go after him.
Guys, it's here, just like they said it would. Since I qualified, it looks like I'm going to get one of these every month. I called in just 3 days ago, and I already got this in the mail today. Now I have more for rent, gas, and groceries. Here's how I did it.
How can I assist you today?
Hi, I'm calling about the health subsidy.
Yes, the $1,400 monthly credit.
Hi. Good morning, or good afternoon, Juror 144. Could you come to the podium for me, please, madam? Okay, madam, you know why you're here?
Yes.
Okay, all right, just want to make sure. You were supposed to come in on the 1st of November to participate in our selection process, and we attempted to reach you by several means to include email and or phone calls from our jury services. Did you get those?
I got a phone call. I never got an email.
Okay, did you have any conversations with our jury services staff?
I did. I spoke with Amy.
Okay, all right. Did she tell you to come in for the 1st?
Well, when I spoke to her, it was on the 1st.
Did she talk with you prior to that? Are you sure you didn't have any discussions with anybody else prior to coming in on the 1st of November telling you how important it was for you to be here on the 1st?
I'm sure.
So you did or you did not?
I'm sure I did not get any type of notification. I didn't speak to anyone directly about being here on November 1st. Until November 1st.
When on November 1st did you find out that you were supposed to be here?
Amy gave me a call.
So you didn't have any conversation. I'm going to ask you again. Did you have any conversations with jury services or anybody else pursuant to this case prior to November 1st telling you to come in?
Correct. That's correct.
All right. So you weren't, you fly for an airline, right?
I fly for American Airlines, yes.
So you weren't in Charlotte at that particular point in time?
At what particular time?
Before the 1st, let's see, on the 31st of October or the 3rd, which would have been a Tuesday, or the 30th of October?
At some point, yes, I was in Charlotte because that's where I'm based, yes.
Okay. And you didn't have any conversations with anybody about coming to Atlanta and about how you were at work?
Yes.
So you did have some conversation about you being at work?
About me being at work, yes.
Okay, all right. And why was it that you didn't appear on the 1st of November?
Well, the reason why I wasn't here on the 1st of November is because I wasn't sure that I needed to be here on the 1st of November until the 1st of November when I spoke with Amy, and she was telling me that it was very important that I be here. So it wasn't clear to me until the 1st that I needed to be here on the 1st.
So you didn't have any conversations the day before about taking a standby flight or anything such as that to come here to Atlanta?
That was on the 1st. All that took place on the 1st.
You didn't have anything on the 30th or the 31st?
All of that took place on the 1st.
And when did you start having conversations with Ms. Von Kelsch about that?
With who?
Ms. Von Kelsch, Amy, our jury clerk.
Oh, I did speak with her on the 30th. I spoke with her on the 30th, as a matter of fact, and I told her that I was at work, and if I needed to be here, to let me know, and that I would be here. And she said, I will let the judge know. But I basically let her know that, hey, I didn't get any notifications that I needed to be here on whatever day, because at this point, it wasn't clear to me that I needed to be here on November 1st. It wasn't clear to me. So when I text her, I gave her my position, where I was and why I wasn't able to be here prior to the 1st. And if I needed to be here, to just let me know. And then I would be here. And then she replied and said, I will let the judge know. Thank you.
Okay, well, by the time that, ma'am, I believe that you're not being totally candid with the court about the conversations that you had with Ms. Von Kelsch and prior to the 1st, because we started to contact people before then to come on the 1st, because we had to conduct the jury selection process at that point in time. How far is Charlotte from Atlanta?
It's 4 hours. 4 hours and some change.
4 hours of drive. 4 hour drive.
It's yes, sir. 4 hours and some change.
All right. Well, madam, I don't find your explanation as to why you weren't here acceptable. I'm going to hold you in willful contempt.
Well, can I say something else really quick?
Sure, you can say something else.
If you would understand my line of business, when I'm flying, I'm in and out of base. And when it comes down to the notifications, because I don't mind being here, it would be my honor to be here. I knew that it was coming, that I needed to be here. I honestly did not know that I needed to be here on the 1st. On the 30th, when I spoke with, I didn't speak to her, it was the text message. I was in Columbia.
Columbia, South Carolina?
I was in Columbia, South Carolina, because I had gotten off of work in Charlotte earlier that day. Now, when I get off, I don't automatically just come to Atlanta. I did not have no idea that I needed to be here until that night, and it was still unclear.
That night of the 30th?
The night of the 30th.
Okay.
And it was that night of the 30th. So at that point, it was no flights for me to get. I don't drive. Well, I don't have my own car, so I rely on that other type of transportation. So my family lives in Columbia. So when I'm off of work, I go ahead and I go to Columbia, or I'll fly here if there's a flight that'll get me here, because I'm standby. I don't have direct flights.
Ma'am, I understand it.
So I am really, honestly telling the truth. I did not know I needed to be here. However, when I did speak to her personally, when we were on the phone together on the 1st, I did everything in my power to get here. I booked flights, but the flights were red. There was no way I could have made it here in time to get here. I even had my 8-month pregnant niece say that she would bring me here. But by that time, she said, don't worry about it. We'll subpoena you so that you can be here. And I still came, but I was in communication. Once I knew that I needed to be here, I was definitely in communication. I wasn't hiding. I wasn't doing any of that. Okay, well, why is it that on the 30th you decided, you just came,
you came to the conclusion that we weren't gonna need you on the first?
Because
or you didn't know whether or not we would need you on the first.
It wasn't clear to me. It was not clear. It was not clear to me that I needed to be here until I spoke with Miss Amy on the 1st, and she told me the severity of me being here. And at that point, like I said, I did everything in my power to be here. I sent flights to let you guys know that, hey, these flights are red. There's no way that I can potentially make these flights. And even if I do make the flight, it'll be probably past the time because it was the connection. There's no direct flights here from Columbia. There are no direct flights here. I have to connect in Charlotte or Philly or somewhere to get here. So that's 2 segments that I have to get here. And I even, like I said, I was trying to get a ride, and my 8-month pregnant niece said, she'll just take me.
You didn't
and
do
I was
that till the 1st of November, though, did you?
Sir?
You didn't try and get a ride till the 1st of November. Did you?
When I realized that I needed to be here, yes. On
Why
the
didn't
3rd.
why didn't you think you need to be here prior to that? I mean, because we tell people we call you, you got to be here. So I just don't.
No one called me.
The court just does not believe that you could have come. You could have made your way here. You had 2 days to get here.
I did not have 2 days. The 30th is what
We contacted you on the 30th, so at least we made positive
Right.
contact with you on the 30th. You'd agree with that, right?
Yes.
Okay, so how come you couldn't have just started making arrangements on the 30th to come here for the 1st?
But I did start making arrangements. I just told you there are no direct flights here from Columbia.
Why not drive?
Because I don't have a car.
Okay, and it wasn't until the 1st that you got your 8-month-old pregnant niece was.
Well, she was the only one that was available at the time because they have, jobs and all that and all of that. I honestly did not know the severity of it until the 1st.
Well, I think you know now the severity of it.
Oh yeah, and I did everything I could. And is Amy here?
She's has other duties at this point.
Okay. Well, I was speaking to her and calling her back to back to just make sure that, hey, I'm coming. I'm going to make it here. And I told her that day, I said, I'm not trying to hide. I'm not trying to do anything. I sent you the flights. I would love to be here.
What time are you supposed to be here on the 1st of the 1st of November?
No one ever told me a time.
So we just called you and told you need to be on the 1st? We didn't give you a time?
It was more like, you need to be here now. When can you be here? Like phone rang, you need to be here. And from that point on, I did everything. I started booking the flights. And I want to say it was around 11 a.m., 10 a.m., because I remember the first flight was around 12. And I still needed to get dressed and get a ride to the airport to get to the airport. And I communicated that with Miss Amy on the phone. And so I said, well, I'm not going to be able to make the 12. I will try to make the next one. Once I realized that I wasn't going to be able to make the flights because, first of all, they were red. I hadn't even been checked into them yet. That's when I said, okay, I need to go ahead and try to get it right. And then my family was trying to help me at that point. Because 100%, that's when I realized that, hey, I need to be there. So, of course, I didn't want to get in trouble. They didn't want me to be in trouble. So, job or no job or whatever the case, I mean, I really tried. I really, really tried. And I still ended up coming. Although she told me not to, I still ended up coming. I was at work. I mean, I can show you my schedule. I can show you the segments of flying. I can show you all of that, whatever you need to see. But I was at work. I was not somewhere just twiddling my fingers and just, screw the world. I was at work. I did not know. I did not know.
Madam, just stand fast a second, okay?
Sir?
Just stand fast a second, okay?
Mm-hmm.
Madam, you can have a seat in the gallery over there. Just have a seat just a second, okay? Have a seat.
Me? Oh.
Yes. Yesterday. got your mess in your report. 9 p.m. Okay, juror 144, come on back up, please. All right, now, I'm in possession of a screenshot. This is the text I think you sent Ms. Monkels. Just want to reconfirm. It says, "Hi, Amy. This is juror 144. Hope you're well and staying safe. I apologize for not being present for any scheduled appearances. I haven't received any notifications regarding it. I'm a flight attendant. I'm based in CLT, which is Charlotte. Correct? Okay. My last trip began on Sunday, 10/29. I work again on 11/2. I will not be scheduled in Atlanta this week. However, please let me know what the courts are requesting from me so I can coordinate with my airline." Do you recall sending that message?
Yes.
And I think that message, just want to make sure, was sent on the 31st. And do you remember Ms. Von Kell sending you back? And that was sent, I think.
That was, yes, sir. That was Tuesday.
5:54 p.m.
Okay.
And then Ms. Von Kell, I believe, texted you back or sent you a message back. Good evening. Thank you all for reaching out. I will advise the judge.
Yes, sir.
So around 5:54 on the 31st, you at least knew that you were supposed to come to Atlanta, correct?
At some point. Yes, sir.
On the 1st.
No one said anything about the first, sir. If I did not know anything about the first until the first, honestly. That's why I said, let me know what the courts need for me to do so I could be there. That's why I said that. Exactly why I said that. I didn't know anything about the first. As a matter of fact, I got a notification at my house on the 31st that was delivered to my house on the 31st that I received. One of my tenants sent it to me on the 31st. And to my understanding, I needed to be in court on the 31st, which was that Tuesday. So because I know that I was at work and I got off earlier that morning or that afternoon, I'm now under the impression that, okay, I'm going to be rescheduled because I missed the 31st. I didn't know about the first until the first. All honesty.
Now, I don't believe you based on what I have. What I have,
But how not?
everybody else appeared when they should have appeared.
I would have loved to be here though. Like, I did not know I needed to be here.
I've given you the time to explain. I'm going to hold him with contempt. Here's your choice.
Yes, sir.
The choice is, it's either contempt is punishable by a fine of $1,000 and or up to 20 days in jail. Okay? We value this procedures is that important because So like any jury ensures that both sides get a fair trial, a just trial, and a lawful trial. I had to literally try and find you because I'm required to account for every single juror that we had to examine at that point in time without fail. So we're waiting here trying to figure out where you are, and this is the only thing I have. Now I understand you got to work and everything else, but I believe that you had enough time and enough knowledge that you could have gotten there in the first. That's what I have. That's where we disagree. I think that you knew that we were trying to contact you at first. You need to be here. So what I'm going to do is 5 days in jail, or you can come between the 4th and the 8th of December and sit here and listen to the case as presented on those days.
I'll be here.
Your choice.
I'll be here.
All right, so we will contact you. You need to be here on the 5th. You need to stay here the entire part of on the 4th. That will be a Monday. Check my calendar. It's the 4th. Find your place. We'll find your place where you can observe the proceedings, and you'll be required to check in on a daily basis. And then after Friday's proceedings are complete, then your contempt will be satisfied. If you do not appear, then I reserve the right to you'll spend the rest of the time in custody. Okay?
Yes, sir.
Right. Okay. So that's how important that we consider these proceedings. So, and that will satisfy your contempt in terms of just coming here and watching the proceedings and being aware of what we asked you to participate in, how important that is. Okay?
Yes, sir.
Okay. All right. You have any other questions?
I do.
Yes, ma'am. What's your question?
So this week, I was supposed to be at work on Monday through Thursday. However, I got a phone call from Lieutenant Gibson saying that I needed to be home because I needed to be served the papers so I could be here today. I'm asking the court if the court could give me some sort of an excuse or some sort of notification to let my job know why I was not at work on Monday and yesterday. I understand about today. The paper only said today. So
why are you asking me to give you something for the last 2 days?
Because I needed to be at work on Monday. However, the fear of God was placed in my heart on Monday to be home, and if I'm not home, it's not going to be good for me if I'm not home. So therefore, I stayed my behind at home.
Well, you just need to be here for the 1st. For today, that's the 15th.
I understand that.
So why is my involvement necessary for the 13th and the 14th?
Because if I wasn't at home on Monday, I would have never got the notification or to sign that paper. I needed to be there physically. I needed to sign it. So in order for me, yes, sir.
So you got the notice on the 13th. You were personally served on the 13th.
On Monday, yes, sir. And I needed to be home to sign it. But I needed to be at work too. So I couldn't go to work because I needed to be home because I understand the severity of this situation. So I was not home. I was not going to work. So because of the way that flying works, I'm not able to go to work, fly a couple flights, and then just come back home. Like when I'm gone, I'm gone. There is no coming back home. So therefore, I had to stay home on Monday to get the paperwork in order for me to be here today. And I had to stay home on yesterday because I needed to be here in place for this morning. Yes, sir, I do.
The show cause at the bottom has November the 13th and it has your signature on it.
Right.
I would think that would be sufficient.
No, because it only, that black and white up at the top, it only says that Mary Frances Green needs to appear in court on Wednesday, November 15th. So my job is like, okay, so what happened to you on Monday? Why wasn't you here on Tuesday?
But, the 13th, you stayed at home to receive service.
Correct.
Well, what's the excuse for the 14th? So what's the explanation I can give them for the 14th?
The explanation that you can give them on the 14th is just jury. I needed to be home so that I can be in place for today. Because again, there was no way that I could have made it to work yesterday and come back to Atlanta in time to be here in position this morning at 9:30 when I needed to be here.
That's an explanation that, if you have to give your employer.
I told them.
Okay, and response?
They took off today and tomorrow because there's nothing on that paper that says the 13th and the 14th. I'm the middle person here. I have to answer to you and your office, and I have to answer to them. And on that paper, the FAA, all they see is that flight attendant was a no-show, which is another fine that I have to do.
Well, I mean, I believe the notice, the amended order shows that you signed for it on the 13th.
Yes, sir.
So, I mean, I can see that. The 14th is a travel day for you. I mean, but I won't have any knowledge of that. And the 15th, you're here for show cause. I mean,
the whole purpose of me not being at work this week is because I needed to be here today. All 4 days. The whole purpose of me missing 4 days of work is because I needed to be here.
the week of the 4th.
Well, I have time now. I have time because I'm assuming your administration is going to give me some sort of paperwork to let them know I need to be there that week.
I am.
Yes, sir. So that's that.
I'm going to give you an order.
Yes, sir. So that's that.
Okay, 0144, here's what I'm going to do.
Yes, sir.
In the order satisfying your contempt, I'm going to state that you received your notice on the 13th, 14th was a travel day, you're actually here on the 15th, and then I'm requiring you to come back, satisfy your contempt, from 4/3/8 by observe these proceedings, and then you'll be satisfied. So that will recall those dates. Is that acceptable?
Yes, sir. Thank you.
We'll have an order to that extent, and we can send that to your email. Probably be done sometime today, tomorrow morning at the latest. Is that acceptable?
Am I not able to get it while I'm here?
No.
Okay. Yes, that's it. I'm so sorry.
I mean, no.
Yeah.
Not right now.
Yes, sir.
I just don't have the ability to do that right now, but I believe that you should get it by the end of business today, or possibly no later than tomorrow morning. I can say that Mr. Burns, my staff attorney, will endeavor to get that out and filed, so you can get an official copy with a ribbon on the top of it saying that Kenny was actually filed in this case, okay?
Yes, sir.
All right, do you have any other questions for me? This is the courtroom you need to be in, okay?
Yes, sir.
Come, and we'll find, or you report it here, and then we'll tell you where you need to be. You'll either be in here or you'll be in 8H, okay?
I do have a statement. If I don't have a question, I have a statement, if that's fine. I just wanted to say that I sincerely apologize about the miscommunication here that took place on everything. I would have loved to have been here. I just did not know. And I do apologize that you and I disagree on that portion of me knowing that I needed to be here. However, what I'm telling you today is the honest truth.
And your apologies is.
Thank you.
I'm going to include, for the purpose of record, the amendment order to show cause and the correspondence with our juror, Ms. Vine Kelsey, the next two court proceedings. Madam, unless you have anything else, we'll see you on the 4th of December for 9 o'clock, okay?
9 a.m.
Yes, ma'am. All right.
1C. Thank you.
Yes, ma'am. See you then, okay?
Yes, sir.
All right. All right, counsel, we're going to take a brief rest before lunch. We'll come back at 2:45. And we'll see you all at that time.
on to now. Hope you're ready, cause I'm really about to put it down. Girl, you know that I will never disrespect you. We love tomorrow, but tonight I wanna spank you. That ass count, gotta make it last now. Start off so, then I'ma beat it up.